Now, members, let's proceed to the next piece of business, and maybe before doing so, it might be important for me to set out the terms of our engagement. I was near saying terms of endearment, but anyway, let's ensure that they're terms of engagement. Last week, I ruled that the process followed by government in relation to judicial appointments could be raised subject to keeping within the limits of parliamentary debate and respecting the normal rules on cabinet confidentiality. As part of the Minister's official functions for which she is accountable to the House, the Minister for Justice undertook a process that led to a name being submitted to Cabinet. The Minister may therefore be questioned on this particular process, including the nature of the process, the steps involved in and how it was actually conducted. These are all objective issues that are in order and do not encroach on other branches of government. The Minister, however, may not be questioned on the merits or relative merits of candidates, nor can she be questioned on how candidates were evaluated with reference to the selection criteria. All persons involved in this process are holders of judicial office, and I would remind members that they cannot comment on their suitability for office. These are all subjective matters that members are precluded from addressing in accordance with the long-standing rules of the House. I would also make the point that the process conducted with the selection of one name for submission to Cabinet, so matters related with Cabinet, including the Cabinet or the Government memorandum and discussions, may not be raised because of the constitutional provisions regarding regarding Cabinet confidentiality. Finally, I would just like to ask members to adhere to the framework that I've outlined. If this framework is followed, it would not be necessary for me to intervene in the course of proceedings, something I don't want to do. However, in the event that I do have to intervene, I would ask members please to respect the fact and to cooperate with the rulings and directions. So now I call on the Minister for Justice, Minister Helen McEntee, to make her opening statement. The Minister has 10 minutes. Minister.
Thank you, Count Corlea. I'm happy to take this opportunity to update the House on the appointment by the Government of members of the judiciary. Over the last century, one of the great successes of the modern Irish state has been the judiciary, which has consistently acted in a robust and independent fashion and earned the respect of fellow judges in Europe and around the world. Since I was elected to this House, and especially since I've had the honour of serving as Minister for Justice, I've been acutely conscious of my overriding duty to uphold and to vindicate the independence of the judiciary. And as Minister for Justice, I will continue to do so throughout this debate. I'm happy to set out the details of this appointment for the information of deputies. However, unlike previous ministers who have answered questions in relation to judicial appointments, I come to the House today as a number of members have put forward a motion of impeachment. It makes it all the more important that everyone in this House today is mindful of their responsibilities. It is incumbent on all of us to uphold the independence and integrity of the judiciary and to not do or say anything which could undermine the courts or any sitting judge, or indeed undermine the separation of powers. We do not have to look too far across Europe to see instances where the independence of the judiciary is questioned. I have participated in the European Union meetings where this very issue was discussed many times. It is important to first set out the process by which judges are appointed under the Constitution and the law. I know many members will already be familiar with this process, given the lengthy debates in this House in recent years over the judicial appointments legislation proposed by the last government. Appointments to the judiciary are made in accordance with Articles 13.9 and 35.1 of the Constitution by the President, acting on behalf of the Government. This is a constitutional function that cannot be transferred, it cannot be delegated. The Constitution prerogative to advise the President on judicial appointments lies with the Government alone. The Government takes this responsibility seriously, and our objective at all times is to propose the best person to fill each judicial vacancy, and I can assure the House that that was also the case when the Government decided to nominate Justice Seamus Woulfe to the Supreme Court. As I outlined to the House in replies to parliamentary questions earlier this week, it has been the practice to maintain a vacancy in the Supreme Court due to the reduction achieved in waiting times in that court in recent years. However, this is of course kept under review. In this particular case, the Chief Justice wrote to the then Minister for Justice on the 4th of February this year, requesting that the Supreme Court vacancy arising from a retirement in June of 2019 be filled. He cited emerging pressures, including the establishment of the Cervical Check Tribunal. As he was obliged to do so under law, the then Minister for Justice wrote to the Judicial Appointments Advisory Board, or JAB, on the 17th of February 2020. In keeping with the usual practice, the Minister asked the Board to furnish him with nominations for this vacancy and the name of each person who had informed the Board of his or her wish to be considered for appointment. The then Minister also responded separately to the Chief Justice, stating that this request of JAB did not presuppose the filling of the post. It was to facilitate the procedure should a decision be taken to make an appointment at whatever point in the future that the vacancy might be progressed. Indeed, the only judicial nomination made during the period of government formation was to the post of President of the High Court, and as this is a senior position, has broader statutory functions, it was done. It should be noted that this appointment on the 18th of June, a week before government was formed, then resulted in the second vacancy on the Supreme Court. It also might be helpful to explain that the Judicial Appointments Advisory Board, or JAB, is an independent board. It was established under the Courts and Courts Officers Act 95 to identify persons and inform the Government of the suitability of applicants for appointment to judicial office. In line with the Cabinet Handbook, between the 11th and 14th of July, I informed the Taoiseach Taoiseach Minister Ryan and the Attorney-General of my intention to propose Seamus Woulfe for the position, following which I brought a memorandum for the Government's consideration on the 15th of July last, recommending a name to Cabinet for appointment by the President. In this case, the recommendation was in line with the recommendations of JAB, which is chaired by the Chief Justice, includes the Presidents of the four courts, as well as the Bar Council, the Law Society and a number of lay members. The process through which the Judicial Appointments Advisory Board recommends applicants for consideration by Government is set out in Part 5 or 4 of the Courts and Courts Officers Act 95 as amended. These applicants are those who meet the eligibility criteria for the particular course set out in the Courts Act 61, so 12 years as a solicitor and a barrister, etc. for the Superior Court. Serving judges are not currently required to apply to the JAB. It is also worth noting too that Section 18 of the 95 Act makes specific provisions that the Board may recommend the Attorney-General for appointment to judicial office. Where the Attorney-General wishes to be considered for appointment to judicial office, he or she shall withdraw from any deliberations of the Board concerning his or her suitability for that office. This is the law. By letter of my predecessor dated the 11th of March 2020, the JAB advised that they had met on the 9th of March and decided to recommend one candidate, Seamus Woulfe, whom it considered suitable for the appointment to the Supreme Court. As requested by the Minister and as required by the Courts and Courts Officers Act 95, the JAB indicated that there was one applicant considered for the post through JAB process, Seamus Woulfe. There were no other applicants. Deputies will note, however, from the annual reports of JAB that this number is in keeping with previous such processes in relation to the Supreme Court, with one application for 2 Supreme Court posts in 2019, one application in 2017, one application in 2015 from those eligible to apply through JAB, i.e. those who are not current serving judges. Under Section 20 of the 95 Act, all proceedings of the Board and all communications to the Board are confidential, so this is all of the information made available to me by that independent Board. As I have mentioned, the outgoing Government made no judicial appointments other than dealing with the urgent appointment of the President of the High Court. So, following my own appointment at the end of June, I was informed by my officials of the vacancy to be filled of the Supreme Court and that the Chief Justice had written to my predecessor on the 4th of February seeking that the position would be filled as soon as possible. A draft memorandum was submitted to my office on the 6th of July 2020. The submission included details of the recommendation that had been made by JAB, expressions of interest from serving members of the judiciary and all other judges eligible for the position. The expressions of interest from serving judges were received over a number of years and retained on file for any current or future vacancies that may arise. Whether or not existing judges put forward expressions of interest is a confidential matter for obvious reasons, and it's not the practice to release information that might identify any of those judges. The practice in relation to appointments or nominations to positions made by Government is that only one name is brought to Cabinet by the proposing Minister. I believe that this practice is particularly important in relation to judicial appointments, as an open debate on the merits or otherwise of sitting judges, as well as others who have been nominated by JAB, would amount to a complete politicisation of the judicial appointments process, when one of the very great strengths of the Irish judiciary has been its non-political character and independence, unlike what we see in many other countries. It is a solemn duty on the part of the Minister for Justice to propose to Cabinet someone who, in the opinion of the Minister, is the best person for the particular judicial vacancy. The Government then decides, and this is exactly what happened in this case. Turning to the future, I think it's fair to say that reform of the law in relation to judicial appointments has been ongoing for some years. Under the previous government, the Judicial Appointments Commission Bill was published in 2017. It was then debated at great length in the Houses of the Oireachtas. The reforms arose from a public consultations process on a review of the judicial appointment system back in 2014. While the Judicial Appointments Advisory Board process was regarded as an innovation in its day, almost 20 years on from its establishment, it was considered timely and worthwhile to review its operation and indeed the entire judicial appointment system to ensure it reflects current best practice. The need to ensure and to protect the principle of judicial independence was a significant factor in the consultation process. This Government has acted appropriately at all times through the current process, which we stand over, having adhered to the process and to the law. But this Government has never believed that the judicial appointments process currently in place is as good as it should be. And that is why we built into our programme for government that we would bring forward new legislation to reform the process very quickly. It seems that we can all agree in this House that there is significant room for improvement in the current system. I am determined to lead that reform and to do so quickly. And I want to work with all deputies to make sure that the new system is future-proofed, to ensure that it meets the very highest standards that we expect in choosing our future judiciary, with the diverse backgrounds and skills reflecting the society they serve. And I know I can look forward to all of the deputies' support in this crucial task. I will shortly seek the approval of the Government for a new general scheme of a Judicial Appointments Commission Bill 2020 to provide for the establishment of a new commission to replace the Judicial Appointments Advisory Board. This will be reforming legislation. There will be ample opportunity for the House to discuss and debate what we need to do, and I intend to lead this reform to make it happen and, above all, to work in the interests of the independence of the judiciary and the public that we serve. And I trust I will have your support to bring about this at the earliest opportunity. Thank you.
Many thanks, Minister McEntee. Now we go to Sinn Féin, and we're going to hear Deputy Martin Kenny sharing time with Deputy McCarthy. Yeah, a copy of the speech can be circulated.
I'm sharing time with Deputy Matt Carthy. Minister, the facts of the matter before us are these. On the 27th of June, you became Minister for Justice. Waiting on your desk when you arrived in the department were 4 applications for the job of the Supreme Court judge. A massive job carrying a salary in excess of $220,000 paid for by taxpayers. You had 4 applications, not 1, as other ministers and yourself have tried to make out, but 4. Whether they came from job or via expressions of interest is immaterial. You had 4 applications. On the 15th of July, you recommended the one name of those applicants to the Cabinet for appointment to the Supreme Court, who just happened to be the previous Attorney General and long-term Fine Gael activist, Seamus Woulfe. So 4 became the 1. I think what any reasonable person would have expected you to do today would be to come before the Dáil and set out how those 4 names were whittled down to 1. But you haven't done that. You have said that you had no discussion about the applicants or their suitability for office with the Taoiseach, with the Taoiseach or with any other Cabinet Minister. This is not credible in the slightest way, because Leo Varadkar, your party leader, knew there were other applicants. In fact, he knew Seamus Woulfe had applied for the position because he said so to the now Taoiseach and Green Party leader during the programme for government negotiations. But you didn't tell the Taoiseach that there were other applicants. Why was the Fianna Fáil leader kept in the dark in regard to this, when your own party leader and other were aware of other applicants? So much of your story just doesn't add up, Minister. Last week you said in response to me at a Justice Committee, and I quote, "I looked at the recommendations that have been made and other expressions of interest. Following that, I spoke to the Taoiseach, the Taoiseach, Minister Eamon Ryan, the Attorney General. On foot of that, a recommendation was made and a name given to Cabinet." Now, Minister, I find it absolutely baffling that the names would not be discussed and that the suitability of those to be appointed would not be discussed by you, as Senior Minister, with the party leaders in government at that time. This applicant was a long-term Fine Gael activist who served as Attorney General in a previous government, yet there was no disclosure, no discussion with your partners in government. But suppose that is the case. Suppose you did make this decision on your own. The fact remains that 1 name out of 4 was signed off by Cabinet, and that name is the name that you brought to Cabinet, Minister. The other 3 rejected applicants were all sitting judges, presumably experienced and very well qualified if they were applying for such an imminent position. Yet Seamus Woulfe, the long-term Fine Gael activist, is the name that miraculously makes its way to Cabinet. I've heard you say that you looked at the 4 names and made your decision. On what basis did you evaluate the applicants? What motivated your decision to bring the name that you did? Was it their experience? Was it their reputation in dealing with complex legal cases? What was the criteria applied for the appointment to the highest court in the land? Because it simply doesn't stack up what you're telling us. You told RTE last Friday evening that you took a number of weeks to consider the appointment. Yet, in response to a parliamentary question, you said you didn't receive the memo detailing the names of those applying for the post until the 6th of July. According to the same response, it was the 11th of July you started to speak with party leaders, who you say you didn't discuss suitability or experience. So it wasn't weeks, Minister, it was just days. None of this stacks up, and that's why we're here today. This was a done deal. A Fine Gael Attorney-General was on his way out, and Fine Gael needed to find a job for him. He was one of Leo's cronies, and that's the Fine Gael way of doing business. And you did it, and Fianna Fáil went along with it. The Green Party, God help them, didn't know what to say or where to look. This was a Fine Gael appointment. It was boxed off long before you ever took office, Minister, and then you signed off on it. That is the reality, and that is why we are here today.
Carthy.
Can Corla, we're here today, as Deputy Kenny says, because Fine Gael in government has a problem with cronyism. They have a problem with doing favours for insiders, and they have a big problem with being held to account when caught out. This is the second time in 3 weeks that a senior Fine Gael minister has had to come before the Dáil to answer questions about their conduct. First, the Fine Gael leader for leaking confidential information to his political ally when he was Taoiseach. Now, the Fine Gael Minister for Justice regarding the highly questionable manner in which the former Attorney-General and Fine Gael supporter Seamus Woulfe was appointed to the Supreme Court. Both cases stink to the high heavens. Both ministers had to be dragged into the Dáil, kicking and screaming. Why? Because Fine Gael doesn't do accountability. Fine Gael does do arrogance, though, in spades. Whether it's one former minister, Brian Hayes, seamlessly moving to become the champion of the banks and the vultures, or another Fine Gael minister, Michael Darcy, moving straight into the cushy job as a lobbyist for high finance. Time and time again, we see the arrogance of the Fine Gael Old Boys network at work. This arrogance, though, is not without consequence. The behaviour exposes all that is rotten in Irish politics. Favours for friends, cronyism and insider deals. And who pays? Ordinary people pay. Those looking for a home, people waiting for a hospital bed, families struggling with mortgages or insurance costs, workers looking for decent jobs and wages. Instead of focusing on what's best for our people, Fine Gael every single time focus on what's best for their friends in high places. People go without so that Fine Gael's friends can have it all. This Fine Gael arrogance is at the centre of this controversy. The Minister insulted the Dáil for weeks by resisting calls to come in here and answer questions. And now, Minister, I have to say, you're insulting the intelligence of people by offering up implausible scenarios, when the truth is that this judicial appointment was an old-fashioned political stroke. It's as simple as that. Instead of bringing clarity, you've sought to muddy the waters in the hope that people will just tire of the matter. I hate to break it to you, folks, it's not going to work. Everyone knows that this was a shady deal. They know it stinks. They know what it looks like when people in power box off a job for their political friend. They know it because they've seen it all before. The reason, Corla, why this process appears to be all over the place was because there was no process. The dogs on the street know that. The reason why the Minister can't properly explain how she whittled 4 names down to 1 is because she didn't. It wasn't even as crass as eeny, meeny, miny, mo. This was eeny, Woulfe. This was a deal done well before Helen McEntee ever became Minister for Justice. This appointment wasn't even decided in the Department of Justice. It was decided inside of Fine Gael. Everyone knows that this was a done deal, and Fine Gael are now trying to take the people for fools. Just as they took the Taoiseach for a fool, and kept him in the dark about an appointment to the highest court in our land. So determined was Fine Gael to get their man through that they ran rings around Micheál Martin to make sure it happened. Cancor, it's not often I agree with a Fianna Fáiler, and it's rarer still that I agree with Dermot Ahern. But when the former Minister for Justice wrote, "It now seems that leading Fine Gael members pulled a fast one by rushing to fill the Supreme Court vacancy with their former Attorney General. The incoming Taoiseach should have smelt a rat. He is long enough around." He was bang on. Fine Gael wiped Micheál's eye in rewarding a loyal friend with a highly paid and very, very powerful job. So, for all the talk of new politics from Fine Gael, we're here again being dragged back to the old days and the old ways. It's this culture of arrogance so typical of Fine Gael that ensures that governments come and go, but nothing changes. Well, people are sick to the back teeth of it. They're sick of the political strokes, the who you knew and who you know manoeuvring, and they're sick of Fine Gael cronyism. And they're determined that the days of the old boys network and of the insider backroom deals are well and truly numbered. Minister, you had an opportunity to come clean, to confirm what everybody already knows. I have to say, it's deeply regretful and disappointing that you didn't take that opportunity. You were party, Minister, to a Fine Gael old boys club political stroke. That's the long and the short of it. You should come clean. You'll have one more opportunity in questions and answers. I urge you now to take that opportunity.
Brendan Howlin.
Thank you, Ceann Comhairle, and can I say that I very warmly welcome today's exercise in proper political accountability. I think it is one of the core functions of this House to hold the Executive to account in all their actions. Minister, I've been privileged to serve in 3 coalition governments, 2 of which were with your own party, Fine Gael. In each government, all senior government appointments were subject to cross-party agreement after detailed discussions of all available and suitable candidates. Few appointments received greater scrutiny than the appointment of senior judges. So much so, in fact, that one government fell in 1994 on the basis of lack of cross-party agreement. While it is correct to say that the Minister for Justice proposes one name to government for appointment, it was never the sole or exclusive right of that minister to determine on their own who should be nominated. The names of all suitable candidates were circulated and considered by the leaders of each party in government. Detailed papers were presented to each leader and a consensus eventually arrived at. As I understand it, Ceann Comhairle, your position, Minister, is that this process was set aside, that you alone made the decision and then presented that decision to the Taoiseach, Taoiseach and Minister Ryan as a done deal, that their advisers, party managers, they themselves simply nodded through your personal choice. I think I'm fairly presenting your position. From a decade's experience in 3 governments, I find that an absurd position. To get listed on the Cabinet agenda, a memo would have to go through a vetting process involving all party leaders involved in government, and especially the Taoiseach. Presumably, your officials prepared the memorandum for government, and in fact, in your contribution today, you said you received a draft memorandum in your office on the 6th of July. Surely you were advised that the previous government, led by Leo Varadkar, had established a non-statutory advisory group outside of JAB to assist with identifying eligible and qualified persons suitable for appointment as senior judges. that that committee was served as secretary by a representative of the Department of the Taoiseach? Were you aware that that advisory committee recommended a number of persons to be considered for judicial office? Did you have regard to the recommendations of this advisory committee in making your choice of who to propose to government to be nominated to the Supreme Court? You previously stated, Minister, that you brought a memorandum to Cabinet proposing a judicial appointment to the Supreme Court, and that memo detailed one name only. The Taoiseach has also suggested that your memo did not contain the information that 3 sitting judges had expressed an interest in the position. Although you tell the House today that the draft memorandum included details of the recommendations made by JAB, expressions of interest of serving members of the judiciary, and all other judges eligible for the position. Was that detail included then in your final memorandum, as it was, as you indicated, in the draft? And in which case, how is it that the Taoiseach was unaware of the others? Did you check if not listing the names was normal practice? Did you examine the most recent judicial appointment memorandum brought only weeks before by your predecessor to check what was normal practice and if it was appropriate to list all eligible candidates for the information of government? The Cabinet Handbook, Section 3.2c states that every memorandum for government should ensure that all relevant considerations are brought to the attention of the government in making a decision. That information provided is complete and accurate, and that any qualifications are clearly stated. Do you believe you fulfilled that requirement of the Cabinet Handbook in this instance? If it was the case that political agreement had been reached between the government parties that the outgoing Attorney General should be appointed to the Supreme Court, I believe that that would be both legal and constitutional. In deference to yourself, sir, as Ceann Comhairle, I'll simply say, however, that it certainly wouldn't be best practice. If it was the case constitutional. In deference to yourself, sir, as Ceann Comhairle, I'll simply say, however, that it certainly wouldn't be best practice. If it was the case that you, Minister, was simply left with a fait accompli on arriving into ministerial office, that there was already a political agreement about who should fill this vacancy, that I think would be politically understood, if not accepted or agreed with. What is undermining your position and undermining the credibility of government is the maintenance of the unbelievable. That you or any Minister for Justice, experienced or not, whether you were 3 weeks in the job or 5 years in the job, would take it upon yourself to appoint the outgoing Attorney General to the Supreme Court in preference to all other applicants, including senior serving members of the judiciary, without discussing the implications of that action with the leader of your own party, with the leader of the other parties in government, and especially, and I underline for constitutional reasons, with the Taoiseach of the day. Are there any self-respecting party in government would simply exclude themselves or allow themselves to be excluded from such an important process? It simply doesn't bear credibility. As Richard Nixon discovered, it's not always the action that is your undoing. Sometimes it's the strain involved in presenting a version of events that to anybody who actually knows the process or who simply follows politics or history is not credible.
Thank you, Deputy Howland. Deputy Councillor Murphy.
Thank you, Minister. The Supreme Court is the highest court of the land. It's essential that those who are appointed come through a rigorous process in order that any vacancies are filled by those most qualified to do the job. That's why process is important. The Judicial Appointments Advisory Board, otherwise known as JAB, is a vetting process. It's all about considering if a barrister or solicitor has the skill set to make a good judge. Once JAB establish an applicant or applicants meet that criteria, their name or names go on a list and they are deemed to be appointable. That's very important. This is not a recommendation to appoint. And please don't keep on saying that it is. Judges don't apply through this process, as we know. I presume that's because they already do the job. They have a track record of doing the job. So they don't have to be vetted for their ability to do the job that they're already doing. So judges apply directly to the Minister for Justice and the Attorney General. Both know the names of those who apply through this route. I listened very carefully to what you had to say in the interview on 6-1. You said following your appointment to the Justice portfolio in June, you looked at the JAB recommendation, I underline that word again, and other expressions of interest. I note you keep calling it a recommendation. And why are you doing that? That's a cover. Following that, you told us that you spoke to the Taoiseach, the Tánaiste, Minister Eamon Ryan and the Attorney General. We know you didn't tell them that some judges had specifically applied for this vacancy. You said a recommendation was made after this discussion and a name was given to Cabinet. You said that only one name is ever given to Cabinet. But Minister, that does not mean that the Taoiseach, the Tánaiste and other coalition party leaders would not be fully briefed on who applied and the process to establish who is the best fit for the job. You said in that interview, considering Justice Woulfe's name was delivered through the JAB, that is the name that was given to Cabinet. That's a direct quote from yourself. You emphasised that Seamus Woulfe's name came through an official process which was chaired by the Chief Justice himself, given the impression that this is a recommendation. JAB was the only official process in all of this. But as I keep saying, it's a vetting process, not a recommendation to appoint. But that process has become superior to any informal application process through which those with judicial experience apply. You were appointed Minister for Justice on the 27th of June, and I want to concentrate on a few things that happened before that date. On the order of business on the 17th of November, Micheál Martin said, I and the leader of the Green Party, Deputy Eamon Ryan, prior to the formation of the government, that I repeat that prior to the formation of government, were told that Mr. Justice Woulfe, the bottom line is very simple and very straightforward. We were simply told that Mr. Justice Woulfe would come through the JAB Appointments Advisory Board. That's it. As far as I'm concerned, he came through the board and was recommended as being suitable for the position. He was an outgoing Attorney General and, in my view, was qualified for the position. In the aftermath of the formation of government as Taoiseach, I had no difficulty with the Minister for Justice bringing his name forward. I had no difficulty in supporting that nomination. That's end of quote. On the 19th of November, the Tánaiste said, I'm pretty sure it was the week before the new government was formed that the party leaders discussed whether Seamus Woulfe would be reappointed as AG or whether there would be a new Attorney General, we decided collectively that there would be a new AG, and Seamus Woulfe would not be reappointed as AG at that point. For transparency and information, I informed the other leaders that there was a vacancy, that Seamus Woulfe had been recommended by JAB as suitable for that vacancy. He was suitable for that vacancy, and that was the end of the conversation. In a nutshell, the Taoiseach told us the decision was made in advance of you being appointed as Minister for Justice. That's because Seamus Woulfe was the outgoing Attorney General, and because he came through the JAB process, that he would get the job. The Taoiseach pretty much said the same thing. So it's as simple as that. The decision was made. There was only one name considered. The other CVs didn't need to be considered. Judicial experience didn't matter. That is what a political appointment looks like. Yet, Minister, you would have us believe that you went off, you worked away on this on your own, you went through all those eligible for promotion to the Supreme Court, including several judges who applied specifically for the role, and that you came to the conclusion that the former AG was the best person to fill the vacancy, and that you were completely oblivious to the fact that this was a done deal. One problem is, as I pointed out, you're using the cover of the JAB as a recommendation rather than a vetting process. If I'm wrong, you need to address the following questions. What criteria did you use to evaluate the applications? Who else was involved? What value was put on track record or judicial experience? Minister, were you aware that some judges, when were you aware that some judges had specifically applied for this job? I also want to know if you discussed this matter with the Taoiseach, with the former Minister for Justice, or with the former AG at any point before you brought the name forward. Were you told who was to get the job? I want to go back to the Taoiseach. One thing I find very strange in all of this is that the Taoiseach made such an issue in 2017 when he was in opposition about the importance of judicial experience. This was in the context of outgoing AG Maura Whelan, who had been appointed to the Court of Appeal. His central point was she lacked any judicial experience, yet there was no issue with a very personalised debate on the floor of the Dáil. Anyone looking back at that, you know, it's very different to today's debate. When an appointment was being made, when an appointment was being made to a higher court, the Supreme Court, judicial experience was not a valued criteria for the Taoiseach or indeed for the Taoiseach, and you would have us believe that there was a fair and equal consideration of all applicants. What I think occurred, Minister, is you received a hospital pass. You've been put in the firing line. You were defending a process by which the appointment was made, when we all know full well that there wasn't a process. Just as you've been put into this position, the opposition have been taken for fools. The nonsensical suggestion that you would come in and, under normal ministerial questions, deal with this was not only an insult, but a dangerous precedent. Those who applied, other than those who applied through the JAB process, must be questioning what was the point. I asked some questions in July in relation to this to the Taoiseach. They were ruled out of order. I was told that under Standing Order 44 that there was no official responsibility to Dáil Éireann in some of the matters that I raised in relation to the criteria for appointment. So in conclusion, we really need a judicial appointment process that truly reflects the separation of powers. And the Social Democrats are of the view that cannot be done with the involvement of the political strand. There must be a total separation with appropriate checks and balances, and that we need a referendum for. We need to end this kind of nonsense.
Thank you very much, Deputy Murphy. Our next contributors are Deputy Breed Smith and Deputy Paul Murphy. Deputy Smith.
Margaret Ceann Corla, to be honest, I find a lot of this debate very amusing. I'm kind of surprised that we're having it, but we're having it. And one of the most amusing statements today came from the Minister herself. The great strength of the judiciary is its non-political character. I was a knots a laughing when I heard you saying that. In essence, many TDs here are expressing outrage that the government has used a vacancy on the Supreme Court to appoint a politically connected person because they were politically connected and not because they were the best or the most suitable person for the job. Newsflash, all of our top judges are effectively political appointees. When Fianna Fáil are in government, we get Fianna Fáil connected judges appointed. When Fine Gael are in government, we get Fine Gael connected judges are appointed. And the odd time, if Labour are the extra wheel, we might get one of their mates. This time we have Fianna Fáil and Fine Gael in government, and Fine Gael got to appoint the judge. But perhaps the outrage expressed is because this is a glaring example of a political appointment as opposed to the more normal and subtle way of appointing judges via the old boys network. Is the outrage because the person appointed wasn't a barrister? The normal route to the High Court is through a judicial system dominated by a very small self-perpetuating elite. The judicial system and the barristers are drawn from a small pool, largely controlled by the Honourable Society of the King's Inn, set up by none other than Henry VIII himself, to ensure controlled access to the bar, but also initially to keep Catholics out. This is the only place where one can become a barrister. Judges are not exclusively barristers, but they are overwhelmingly so. The Honourable Society of the King's Inn is the only place that trains barristers, but there isn't a statutory basis for this in any law made democratically by us. It literally owes its origins to Henry VIII and was set up to ensure that small, well-vetted elite controlled who got to be a barrister and who was kept out, and they still do it. Except inside the Honourable Society of the King's Inn, there's another secret society known as the benchers. There's an inner bench and there's an outer bench, and anyone who is made a judge automatically becomes a member of the benchers. And they have secret dinners. Nobody ever finds out about them, but they happen regularly. And I wonder if some of the outrage is caused by the fact that Seamus Woulfe wasn't even a bencher. The idea that the Justice Minister has appointed a candidate because that candidate was a Fine Gael activist, we are in for now a bigger shock. So get the smelling salts ready. And here's another news flash. There is no such thing in reality as the separation of powers. We have a political system dominated by Fianna Fáil, Fine Gael, with a splash of Labour and this time round the Greens thrown in. We have a judicial system dominated by the Friends of Fianna Fáil and Fine Gael with the odd Labour appointee. But in expressing outrage about that fiasco, I would like to say to the other party leaders, to Mary Lou MacDonald, to Alan Kelly and to Catherine Murphy, that next week you will have a chance to show outrage and support the motion tabled by People Before Profit and Paul Murphy to remove Seamus Woulfe for stated misbehaviour. You can demonstrate that we are serious about the separation of powers and we're serious about democracy. And just as importantly, we're serious about demonstrating that we recognise the huge sacrifices of the Irish people for the last 9 months by abiding to the public health guidelines, and that these guidelines were not made just for the little people, but were also made for the great and the good, whether they came from the Benchers Club or not. Lastly, if Paul will bear with me, I have a couple of questions. I wonder, Minister, if you are aware that Seamus Woulfe is a former branch secretary of Fine Gael in Dublin Bremer North, if you're aware that George Birmingham, who sat on the Judicial Appointment Advisory Board that recommended Seamus Woulfe, was a former Fine Gael minister, if you're aware that Seamus Woulfe had sat on a previous JAB board that recommended George Birmingham for a position as President of the Court of Criminal Appeal, and did you think that there's a danger of you scratch my back and I'll scratch yours? And did you know that Frank Clark, who also sat on JAB, that recommended Seamus Woulfe, was a former Fine Gael candidate for the Seanad? I think you should have found this distasteful, that a body with so many Fine Gael connections should recommend somebody with a Fine Gael connection.
Deputy Paul Murphy.
Thanks, Ceann Corla. I find it quite outrageous, to be honest, that after 2 weeks now of ducking and diving by the government, trying to shield the Minister from questioning, that we get a statement that goes on for 10 minutes and manages to avoid the central issue about which questions have been raised. And that central issue is, if your story is accurate, then on what basis did you decide that Seamus Woulfe would be the name that you would recommend to the Cabinet? On what basis did you decide that it would be him rather than the other judges that were on the memorandum before you? It's a bit astounding that you can manage to talk for 10 minutes and avoid the central issue about which questions have been asked repeatedly. What this controversy is about, I think everybody knows what it's about. It's about whether Seamus Woulfe was a political appointee. Was there either a deal between Fine Gael and Fianna Fáil, that Fianna Fáil gets the Attorney General and then Fine Gael gets their former Attorney General onto the Supreme Court? Or did Fine Gael pull a fast one? But either way, is Seamus Woulfe now on the Supreme Court because he is close to Fine Gael and was a Fine Gael activist? That's the central question. And the dogs in the street are in no doubt about what the answer to that question is. And in fact, as Deputy Murphy referred, in a way, the Taoiseach gave the game away when he spoke in the Dáil on the 19th of November. He pointed towards the truth of the arrangements that had taken place. But for those outside who think it's just blaringly obvious that this is a political appointee, they have very good reasons for suspecting that it is. In 2011, the Irish Independent did a survey of judges and found that 1 in 3 have personal or political connections to political parties. It's wildly disproportionate to society at large. We don't have that kind of mass participation where 1 in 3 in society are members of political parties. It should be noted, of course, that you won't find judges that are personally and politically connected to parties of the socialist left. It is overwhelmingly Fianna Fáil and Fine Gael, the traditional establishment parties of Irish capitalism, which are wildly overrepresented within the judiciary. So it's perfectly normal, as Deputy Smith has said, to have political appointees, unfortunately. To deal with the story, which is not at all a credible story, but let's take it on its merits, the story that the Minister presents before us and about which we'll have a chance to ask questions and hopefully get some answers shortly. The timeline of the Minister goes as such. On the 29th of June, she's appointed to be a Minister. On the 6th of July, she gets a memorandum which includes the name of Seamus Woulfe, but also includes, importantly, other names. Then on the 15th of July, she brings a memo to Cabinet and a recommendation with the other names stripped out and Seamus Woulfe's name alone remaining. That's the essential parts of the Minister's narrative. And crucially, apparently, between the 6th of July and the 15th of July, or earlier if she knew earlier, the newly appointed Minister, at that stage 2 weeks in the job, doesn't talk to a sinner about it. Doesn't talk to the Taoiseach and her party leader, doesn't talk to the Taoiseach, doesn't talk to the leader of the Green Party, although that might not surprise people, doesn't talk to the Attorney General, doesn't talk to the Secretary General of her department, doesn't talk to a sinner, and instead looks deep inside her heart and decides, yeah, it's this one, Seamus Woulfe, he's the man for the job, as opposed to all these other people. It's very blatantly and very obviously not credible at all. It very clearly isn't what took place. But there is a question that flows from that, which is that if it's the case that the Minister on the 6th of July got a memo with a number of names and then the Minister chose to strip out the names and leave one remaining and bring that to Cabinet, well then, on what basis that the government then decides to appoint Seamus Woulfe as Supreme Court judge, on what basis can it be said that the government met and acted as a collective authority? Article 28(4)(2) of the Constitution is clear: the government shall meet and act as a collective authority. But if the Minister never mind bring the names, But did the Minister inform the Cabinet that there were a number of possible options? Did the Minister bring the information? Because it cannot have acted collectively if it didn't know that there were other applications and if it only thought there was one from Seamus Woulfe.
Thank you very much, Deputy Murphy. Now, on behalf of the regional group, Deputy Peadar Tobin Gamalishkill.
Minister, everybody listening to this debate at home will be familiar with the recruitment process for a job. Most people listening to this debate will have been through some level of a recruitment process in their own work. Everybody understands that a recruitment process should be fair, it should be open, and it should be transparent. And that the person with the person with the best knowledge, the best experience, the best character and the best skill should be the one that's selected for the job. So in other words, that we live in a meritocracy, and merit is the basis for the selection of any position within the country. And that should go from the bottom of society to the very top of society. It's not rocket science, Minister. It's a basic standard that people demand in their own working lives. For the applicant, it ensures that there's fairness, and for the recruiter, it also ensures that the best person is selected for the job. Now, look at how this country works. For far too long, Ireland, people have got jobs on the basis of who they know and not what they know. The establishment parties for years have divvied up jobs on the basis of party affiliation. When I was a kid, if you wanted a job in Telecom Éireann, you went to your local Fianna Fáil councillor and you got a job in Telecom Éireann. That culture is still alive and well, and I know of Fianna Fáil and Fine Gael politicians who still make representatives for their supporters for state jobs in this country. So we also saw the inner circle as it functioned just a couple of weeks ago when we saw the Taoiseach himself leak confidential and not for circulation document to his friend. So people recognise this culture as part of who Fianna Fáil and Fine Gael are, and they recognise the gross injustice of it as well. Now, with regards to what's happened in the last couple of weeks, the Taoiseach and the Taoiseach have hid behind a smokescreen they call the separation of powers. But surely the biggest threat to the separation of powers is a culture which allows for party affiliates to be the individuals with the fast track for the position of judges. If we want to really separate the Oireachtas from the judiciary, we need to separate the selection of individuals from the party system as well. The majority of Attorney Generals in the history of the state have been made senior judges. 16 of the 31 Attorney Generals have gone and got senior positions ranging from the Court of Appeal all the way up to the Supreme Court. And other AGs were actually appointed judgeships but refused them for their own personal reasons. So we know that there is a natural conveyor belt system, if you like, already in this process. Judges at all levels have been party members, speech writers, candidates, TDs, ministers, close friends and siblings of politicians. And it's not just Fianna Fáil and Fine Gael who've been involved in this practice. The Labour Party have been eager participants of this practice over the years as well. So what's the remedy to this situation? Well, surely the remedy to this situation is transparency. So if you have a clear and transparent process for the recruitment of the most important job of the land, we know that that's a remedy for the situation. And second remedy to this is that a minister and the government who need to be willing and open with regards answering questions to the process itself. It's an incredible situation at Ceann Comhairle that if you ask most Irish people currently, do they know more about the US process for selection of judges to the US Supreme Court than the Irish Supreme Court, most people will say that they know more about the US system. It's an incredible situation. And even I heard government ministers on radio shows being asked about the process of selecting people for the Supreme Court of this land, and the ministers themselves shrugged and weren't even able to answer those questions. Why does the process of selecting judges in this country have to be more opaque than the third secret of Fatima? And I tell you why. Because it suits the political establishment to do things behind closed doors, not to have open transparency on the process. So in 3 weeks, Minister, you have had a situation where you had to make a choice on who is going to be the next judge of the Supreme Court. And I just think it's interesting that in all of the speeches and radio interviews that I've heard you involved in so far, you focus on one list only. But there are two other lists, Minister, with regards choosing candidates for the Supreme Court. These lists, first of all, are those who are eligible for promotion to the Supreme Court. I never hear you mention that particular list. There's also a list of those who are interested in appointment to the Supreme Court. Again, a lack of detail there. Both of those lists are held with the Attorney General, Minister. So I would like to know from yourself, did the Attorney General give you these lists? And when exactly did the Attorney General give you these lists? And is it plausible, to be honest, that the Attorney General would not have, at some level, discussed these lists with the Taoiseach, the man who appointed the Attorney General to that particular position? Now, for this process to be clear and open, we need to know a large number of things, Minister, from yourself. So in the 3 weeks in which you had to select this particular judge, did you work out the existing experience or skills gaps that were on the Supreme Court, and how did you do that? Did you go through the volumes of published judgments that are there from existing judges? Did you do all this individually by yourself, or did you have a team to do this? Did they produce a shortlist for yourself? Did you interview any of the applicants, or did any of the applicants, or at least a third party, make a presentation to you of each nominees or each individual that was available to the job of their particular skill sets? And why did you select the candidate with the least level of court experience in all of the individuals that were interested in the job? I suppose a big issue for myself is it is very hard to believe that the Minister for Justice would go through all of this process and never mention the names of any of the other candidates to either the Taoiseach or the Taoiseach. Does anybody think it's credible that in a system which is, as we know from the debates here, is already knee-high in the political horse trading of a particular government, that you did not at any stage speak to your political bosses with regards to the applicants of these jobs? And if you didn't speak to the Taoiseach or the Taoiseach, 3 weeks into the role, who did you get advice from with regards to this? I believe that most people listening to this particular debate will understand what everybody else understands here, that the decision was already made and that the process in actual fact was separate to the particular decision. I would like to know, has any of the people who applied for the role been in contact with you since? And is there a process open to them where they can maybe articulate discomfort with the fact that they have been overlooked in this process? We need to have confidence in the judiciary, and I will say that in any research that's been published throughout the country, the judiciary rates very, very high with regards to confidence amongst people. These questions are not designed to impugn the name of the judges, but just to focus a process that's happening here. And the truth is that this process and the lack of transparency, Minister, has done significant damage. And I also note, and I'm 10 years in here at County Corlia, that the standard response to ministers when they get in trouble is that they did everything right in relation to the process, but now it's been revealed to them magically that the process is wrong, and that they're now going to do the best they can to fix the particular issue. But I honestly think at County Corlia that that's horse manure. If the opposition did not seek to flood this issue with the light of transparency, you can bet your bottom dollar that it would be business as usual for this government with regards to this. This is the equivalent of a child being found with his hand in the cookie jar and then advising his mother, well, it's your fault for leaving the jar too low. Politicians and political parties are forever calling for political reform here. And I have to laugh, because the most obvious place to reform politics is within political parties. It's for the political parties themselves to resist doing things that are obviously wrong, such as this. Laws and regulations are necessary only when the people concerned do not have the moral compass to do the right thing. And I think, obviously, County Corlia, from what we've seen here and the history of the political establishment and the selection of judges in this country, that moral compass does not exist, and therefore we need to change the law to make sure this can't be done again.
Thank you very much.
Earns this debate. We still don't have a copy of the Minister's speech being circulated here.
Presume that has been looked after. We'll make the arrangements.
No, but Can Corler, people need a chance to read the speech and prepare for their questions. So I'm asking that we just delay this for a minute till we all get a copy of the Minister's speech.
Well, no, we won't be delaying it, but the speech, it would be most helpful if the speech could be circulated. Outside the door. Well, maybe somebody would bring it inside the door.
I don't think they're allowed under COVID. I think that's the situation.
We're moving.
No, I'm serious. No, they can't.
We're moving on.
No, that's how it was taught last week.
We have personal suitability that may reflect on somebody who has already been selected. It has happened on numerous occasions here already today. It should not continue in this House.
Deputy Matty McGrath next, please.
I wonder, have you been since now, Controller? You've been lectured as to how to. You're doing a fine job always, and very fair, I find out. But this is extraordinary. And honestly, I believe the whole timeline around this situation is extremely. It's very, very, very utterly unsatisfactory and extraordinary. And I wonder, and I'm worried, and I'm concerned about the people at home looking on or reading this. And this up to their necks with the COVID situation, or down to, under the floor in debt and in fear and anxiety and in trauma with what's going on at the present time. And then we look at this side by side, what's going on and how long it took to have these questions, they albeit limited. And I just want to go back on the timeline again, which I feel is utterly extraordinary. June 2019, Supreme Court Judge Mary Finlay-Gagan retires. 14th of January 2020, general election called. January 2020, Mr. Seamus Woulfe applies to JAB for Supreme Court job. February 4th, the Chief Justice Mr. Frank Clark, writes to Minister of Justice, Mr. Flanagan, seeking a judge for the Supreme Court. February the 8th, the general election. We were all very busy. February the 17th, the Minister of Justice, Mr. Flanagan, writes to JAB, chaired by Chief Justice Frank Clark, asking them to send and recommend a Supreme Court judge. March 2009, JAB sits under Chief Justice Frank Clark and clears the name of Mr. Seamus Woulfe as the only name for the Supreme Court vacancy. March 11th, JAB writes to Minister Flanagan informing him that they have indeed cleared Mr. Seamus Woulfe's only name. June 27th, in a long gap, the new government was formed after all those talks and anxiety and wheeling and dealing and horse trading and God knows what else goes on. But I do know that as far as us and rural independence, we were interested, but we wouldn't want it. Except near the government, and we have good reason to know why. Minister McEntee brings the only named in Minister Seamus Woulfe on July 15th to her first cabinet meeting, I believe, I stand corrected on that. This is deeply suspicious. If Gael AG, Mr. Seamus Woulfe, applies to JAB, chaired by his old friend and Chief Justice, Mr. Frank Clark, to a Supreme Court vacancy. It has been vacant for 7 months, which is extraordinary. Suddenly, Gael faces a possible loss of office because of the result of the election, and Justice Clark decides to get moving here and sets the wheels in motion in writing to Gael Minister Flanagan, telling him, Mr. Charlie Flanagan, telling him he needs a judge to be appointed. Minister Flanagan writes to JAB, chaired by former Gael supporter and the same Mr. Frank Clark, and asks them to convene to consider the vacancy. They meet in haste, send up Fine Gael supporter Mr. Seamus Woulfe's name back to Minister Flanagan. Minister Flanagan suddenly decides to sit on it, the nomination for over 3 months. 3 months, 12 weeks, until the new government arrives. He and Minister McEntee appear to have binned the other expressions of interest from well-qualified judges. He hands the minefield over to Fine Gael's new Minister of Justice, Minister McEntee, who takes it to Cabinet. It is absolutely crystal clear that Minister Helen McEntee did not take this decision alone, and probably an absolute innocent indeed, doing the parties, whatever kind of work you want to call it, but it starts with a D. I think it's shocking, shocking. And what process was followed for the other judges appointed on the same day, the very same day as Mr. Seamus Woulfe's appointment, Justice Woulfe now? Where did Minister McEntee get the advice for these appointments? And did Minister McEntee consult with Taoiseach Micheál Martin and Green Party leader Eamon Ryan, and indeed Tánaiste Deputy Varadkar, or indeed former Minister Charlie Flanagan on this? In particular, did Minister McEntee speak to former Minister, now backbencher, Deputy Flanagan, about Mary Morris's appointment, Miss Mary Morris's appointment to the court? And question mark, did she know that Miss Mary Morrissey, Justice Morrissey now, had once worked in Charlie Flanagan's political firm? I mean, I haven't great eyesight, I have glasses, and thankfully, but you need a blind man to see what's going on here. A blind man, there's none so blind as those who cannot see at all. This is things from the high heaven. And it's sad, and it's extremely sad, because and I have no truck or no interest, as I said to you, Count Corner, the day we met, not your sensitive Taoiseach, sorry, but I've assured you that the rural independents have no interest in engaging in a witch hunt of Mr. Justice Seamus Woulfe about a process of impeachment. There's no grounds for it, and we couldn't do it if we even wanted to. So I won't be supporting that, and make that clear from our group at the Rural Independents. But we have to get this sorted. And would these shenanigans, would this have happened if Minister Ross was still in the Cabinet? He lost his seat, unfortunately, and we had many good row, but nonetheless he tried gallantly for decades, writing about it, but in Cabinet and in the Senate and indeed in the Dáil as an independent backbencher to have reform of the process. And we got some reform. We got a Judicial Appointments Board, no, Complaints Board, and signed into law, debated here, signed into law about 6, 7, 8 months ago by the President. And I believe the building is rented. I believe it's staffed to full complement. All they're waiting is the doorman to open the door so that Joe public can make a complaint. But why are they waiting until next June to do it? Why is it being delayed? There's some very sinister questions and reasoning behind this, and I won't put them on record here, but I know what they are. And it's the murky business that's going on. And we do have separation of powers, Count Kohler, and you can stop me if I stray, but we have people today in the forecourts. The courts aren't meant to be sitting about evictions, and they're meant to be sitting at the moment, but they have been right throughout the whole pandemic. The first part of it, and now the second part of it. And we're supposed to have the moratorium in the banks, and people are being evicted from their homes.
Please,
Sorry?
Deputy, don't go there.
I'm not going there. I'm just telling you what's going on. A process. We're saying it's not going on. We're hiding that murky business, and it's going to be an avalanche. Going to be an avalanche after in the new year with the bank's moratorium lifted, and the friends we can see the Fine Gael friends in the bank. The poachers become gamekeepers. Informal ministers going in to be the powerful jobs there, and we know it. We see it. We saw, and then there's unregulated thugs going around the country, and they were brought before courts and fined as it's carrying on the heavy gang. Some of them mercenaries from other countries with murky pass. And the regulation agencies in Tipperary, and I've made complaints there. I went and met him there, and indeed the chairman came up to the door to meet Deputies Collins and Carol Nolan and myself about the situation, but it still goes on. We're supposed to be representing the people here. We have a constitutional right to defend the people and not to persecute and to drive them into oblivion. We had that for generations and centuries by the British. We had Bloody Sunday, which we celebrated last week, and we were proud Tipperary people to get out in that field, albeit in Cork, and win. And the spirit of that jersey and the spirit of the people that fought for this country, I'm talking about Trassick and Breen, and indeed, as I said, Michael Hogan, and those people who spilled their blood, and countless others. For what kind of a democracy did we get? We looked for it and we fought for it. What have we got? It's as twisted as some of the juntas in Africa and other places that we talk about. It's shocking. It's sad. I'm privileged to be represented here for the moment, represent the people of Tipperary for the moment, and I respect that greatly, and I will abide by their wishes in future elections. But it's sad that this goes on and continues to go on. And the Fine Gael think that they can do what they like with this. It's there preserved, because they were so long out of power, since Paddy Dunnigan and Paddy Coney and that gang were there, or at risk some of them now, and all of them dead, I don't know, but that, the heavy gang, they operated in 73 to 79. You've heard me refer to it, 73 to 77. You've heard me refer to it, that has crept back into the Business Committee by some of the enforcers who were shouting a minute ago for you to make sure before I got up to be censored and be controlled. But I won't be censored or controlled by Fine Gael. But the sad part about it is that we have a sad situation of a Taoiseach now was so beholden and craven to get that job. He's got his prizes, like got his first communion, or got his leaving cert, or whatever. And whatever happens, not get away and him losing his job. As he knows, with fear and terror, that Leo is riding behind the poles, or Minister Bradke, sorry, and if he kicks up, they'll dump him over and we'll have an election. And he'll be gone. That prize will be taken away from him, that he much looked after. He's looking for it for 25 years. And he got it. And kicked out his own ministers, Barry Cowan, kicked out his own minister, Derek Cleary, and Save the Fine Gael skin. We saw it 2 weeks ago with the Taoiseach, answer the questions, now Taoiseach, and we see it here again today. But the Fianna Fáil can be sacrificed. A proud party that was founded member of my father can be sacrificed to the world for the sake of naked greed of power and luxury. And what else? So we see it every day here with disdain when we ask questions about what's going on. We can't get the information about the figures that are data about the COVID counts. We can't get the science. And we protect it. Doesn't matter what happens. God, if a tsunami came, once he could swim over, he'd stay up, keep his head above the hill, and the hell with the crappies lie down. Forget the country. Forget the people who fought for Ireland. Forget the families struggling today. Forget the workers that are out there trying to work and carry on and try to make a living and eke out a living. And let the big businesses and the banks and the insurance companies and the vultures carry on the murky, dirty, messy work of sucking the lifeblood out of the fighting spirit of the Irish. And I ask, and I put a call out to the fighting spirit of the Irish to rise up and not take this disgraceful behaviour. It's pathetic. And I wouldn't, in the spirit of C.J. Kickham and Monaghan, won't take it, accept it. And the spirit of the McEntee family in Castle and many others, and T.J. McEntee fighting there. The ballot box is going to change all this very soon. We thought we got it the last time, but we didn't. They have control, and the fingers are on the handlebars of power, and you need a chisel and a hammer to get them off it. Good luck.
Thank you very much. Now, sorry? We go. Thank you very much, Deputy Keogh. Now we'll go to Deputy Michael McNamara. Finally, is sharing with Deputy Catherine Connolly. Deputy Catherine Connolly, the other way around.
Deputy Catherine Connolly, 10 minutes. And I welcome this opportunity to participate in the debate. And I would like to think it's the start of a bright light shining on the opaqueness of our appointment system in relation to the judiciary. I want to say from the outset, Minister, I believe you've been handed a hospital pass, and that phrase has already been used by Deputy Murphy. And in a previous life, while we were delighted to get a hospital pass as a barrister, we knew exactly what it meant. And I think that's what's landed on your lap, is a hospital pass. It's regrettable that it has taken this much effort to have this limited debate in this manner. And I put the blame squarely on the Taoiseach. I'm afraid he has learnt nothing. And earlier this week we were looking at the lobbying bill brought forward by Sinn Féin. And again, I stood there and I had read the SIPO reports, and I asked myself, why have we to rely on opposition, and fair play to Sinn Féin for bringing it, to bring changes? And so SIPO had told us repeatedly what changes were needed, and yet in January of this year, the former Minister for Public Expenditure told us no changes were necessary. And so it took all of the scandals today, the revolving door, plus the initiative from Sinn Féin to force some type of change. And even then, the government said we need 9 months. Now, similarly with this, why do I mention that? Because I looked back, and I want to thank the media, actually, some parts of the media in relation to this story, because without them, we would have very little information, and certainly we'd have none if we were reliant on the government, because what the government have told us, they have done nothing wrong, and they've complied with the procedures, and the procedures being totally opaque, because nobody knows how they work. And so if I look at the former Chief Justice Susan Denham, when she left and retired in 2017, and among very many interesting things that she said in her farewell speech, she talked about the lacuna that were there and the necessity for change. And she said the lacuna is there in spite of many years of discussion. She first discussed the matter back in 1997 with Nora Owen, and what was needed in terms of legislation, training for judges, a more transparent system for appointments, and so on. She also referred to the eyes of the Council of Europe, which has been referred to many times. And in 2007, she referred to a report from Greco, which was 2014, which made 5 recommendations: that a judicial council be established, that the system for appointing judges be reviewed, that a special pay and conditions body be established for the judiciary, that a code of conduct for judges be formally established, that a dedicated training institution for judges be established. And she said in 2017, notwithstanding that those recommendations had been made by the Council of Europe, or the body acting under their aegis, not one single recommendation had been acted upon. And this was the judiciary asking for change. Greco have continued to publish interim compliance reports amongst other reports, and they are still not happy with the rate of change in Ireland. Now, I disagree with the comments of Deputy Smith, and mostly I agree with her, but I think it's remarkable that the judiciary have been independent. And indeed, I remember Justice Niall McCarthy, deceased, and he stands out and tried to hold the government to account in relation to the amendment in the Constitution in relation to the abortion referendum and so on. And also Peter Kelly, amongst many other judges. Now, I'm not here to make any apologies for judges, but it's remarkable their independence. And in my moments of despair with this institution here and with the Health Executive and many other institutions, the judiciary stand out as the last bastion for an ordinary person on occasions. The biggest problem, of course, is that most people don't have access to the courts because it's way too expensive. And I wish that's what we were talking about today. In relation to your speech today, I would call it disjunctive. I don't think the paragraphs follow from each other. And again, I think you're in a very difficult position. I think the Taoiseach should be in here answering these questions today and setting out what has happened. He was well able to speak when, on the last occasion, Fine Gael and Labour allowed the then Attorney-General to go to the Court of Appeal, and he called it an insider job that stunk to high heavens. I take that back. At that point when it went up, his comment was that it stuck to the high heavens. I'm not here to score political points. What I'm here to outline is that each government has absolutely failed to learn that we need to change the process in relation to appointment of judges so that it's not opaque. If I stay with Justice Denham for the moment, she said, paying tribute to the media, she said, I would like to thank the journalists who have reported on the work of the Supreme Court during my tenure as a judge of the court and as Chief Justice. And this is what's significant for me. For the rule of law to flourish in a democracy, an understanding and knowledge of what happens in our court is required. And I would add to that and say, for democracy to flourish, what we need is a knowledge of how institutions work, and particularly governments and the executive, and how they appoint judges. And it seems to me that there is no openness and accountability at all in your speech today, nor in the manner in which the former Attorney-General was made a judge of the Supreme Court. I have no wish to comment on the merits or otherwise of that appointment. I'm commenting on the process. It seems to me extraordinary that one of your paragraphs refers to the fact that it was practice to leave a Supreme Court vacancy. I find that extraordinary when we have a Chief Justice writing in February to urgently fill the appointment. We seem to have many parallel systems of appointment. Remember, back in 1995, the Act was brought in to bring some measure of reform to the appointment system. That jab through which the former Attorney-General went was one point. Then we have judges who are interested, and they send their expressions of interest through the Attorney-General or the Minister for Justice. You haven't clarified here today, is it the Minister for Justice that receives those expressions of interest from the sitting judges, or is it the Attorney-General? And if it's the Attorney-General, has anyone asked, is there a conflict of interest from any Attorney-General that, sitting as Attorney-General, wants to become Supreme Court on this hand, and on this hand he has the applications from the sitting judges who are interested? Has anyone thought about that, or how that conflict is handled if there is a conflict? Certainly, in my opinion, it has all the appearances of a conflict. You haven't dealt with that whatsoever. And then there's the third system where we have judges who are there but they haven't come forward, but the government is allowed to consider those. What is the procedure for looking at that? Does it not strike you that we, as a republic and a democracy, that is not open and accountable. That's not an open and accountable system. And we can't call ourselves a republic and a functioning democracy if we don't have an open system. Following the debacle in relation to the previous Attorney-General being appointed to the court, and again, absolutely no comment on the person, just what happened. Following that, and Deputy Howlin himself has referred to this, I understand there was a review by Martin Fraser, and following that review, a committee was set up parallel with the jab situation, and this committee was made up of the Chief Justice, a layperson, and other distinguished people. We're not aware who or how they were appointed, how they functioned, but it seems to have functioned well, and it seems to have been instrumental in appointing a number of applicants to the higher courts. And where did that go, Minister? Were you told about that? Where did that system go? That's a kind of a fourth part of the jigsaw now. The jab, the notices going straight to the Attorney-General or to the Minister, nobody's clarified that, then the sitting judges that the government can pick, and then this advisory committee that was set up following the previous debacle, in relation to which Micheál Martin said it stunk to high heaven. What happened to that setup? Now, it would be helpful if that was outlined to us today. It would be helpful if you were here today saying, we cannot stand over this system anymore. This is the way it was always done, but it can't go on like that because, number one, we're in trouble in Europe because we're pointing the finger at other countries, and rightly so, but we need to look in the mirror first. We need to look at what the Council of Europe, through their organisation, Greco, have highlighted repeatedly. And I'll finish up by saying the irony, of course, of all of this is the fact that we don't have a system in place yet in relation to complaints about judges' behaviour. And so a lot of the information we have here is by default, because we didn't set up a system, a fair and just system for complaints in relation to judges, as happened in relation to the former Attorney-General, who's now Supreme Court Judge, Seamus Woulfe, and his attendance at Golfgate. We had no procedure in place to deal with that, so we go back to the former Chief Justice, set up an informal system, and a total mess ensues in relation to that. But we learn from the openness and accountability of when they printed the transcript, certain facts in relation to how Seamus Woulfe was appointed. That's ironic in itself. I hope it's the start of stronger light, and I hope it's the start of reform.
Thank you very much, Deputy Connolly. Now, that concludes the first part of this debate. At the outset, I asked members to stay within certain parameters. Some members may have pushed towards the boundaries, but I do accept that people have respected the request I made to them. Deputy Griffin up there wishes to advise me that he doesn't think it's like that, and I'm very grateful to get your advice, Deputy Griffin, from time to time. But what I think we have heard is some severe political charges, and I don't know that they're necessarily helpful, but so be it. Can I ask members now, as we move on to the actual questioning process, please to have respect to the parameters within which we must operate, and we're going to have to stick rigidly to the 5-minute time. I think it will also be helpful if deputies indicated, are they going question back and forth to the Minister, or are they going to have a couple of questions, leaving the Minister time at the end to respond? So our first questioner, Deputy Martin Kenny.
Thank you, Ken Corla, and I think it's better if we do a back and forth, if that's
okay,
possible.
Well, let's get on with it.
Okay. We all know that there's some facts we need to get out here, and we all know that Seamus Woulfe is a long-time Fine Gael party activist. That's not in dispute, Minister. You haven't disputed that, nor has anybody else. He sat around the Fine Gael cabinet table for 4 years. You became Minister on the 27th of June. You got a list of 4 names on the 6th of July, including candidates of long judicial experience. In record time, in a matter of days, you whittled that down from the list of 4 down to 1, and off to Cabinet they went with a single name. Now, your speech said nothing, really, as to how that process worked, and you don't really seriously think that people believe this yarn that a process was followed here, because nobody believes that. Do you seriously think that people believe the yarn that it wasn't a Fine Gael political stitch-up? Because that plainly is not the reality. You have to stop fooling people. And Minister, what you need to do is you need to recognise and admit that there was no process, that there was no evaluation because you haven't outlined one, and there couldn't have been. And I think, Minister, what you need to do is admit that here to your colleagues in this chamber. Minister.
Thank you, Deputy. Firstly, what I will say is that I don't think anybody's political persuasion should prevent them from being promoted or go through the ranks of any job, whether it's for a judicial appointment or not, and I want to put that on the record. Secondly, what I will outline, I was appointed on the 27th, which was a Saturday. On the Sunday, the 28th, I came into the department, and as is customary, I was given a huge amount of notes and information. As part of that information, I was told by my department that there was a vacancy, that there was a request from the Chief Justice to fill it as soon as possible. I also found out within those first few days that there was a list from the Judicial Appointments Advisory Board, because that was already in my office from the previous Minister. That was obviously made available to me, that there was one name. When I talked about the document that I received on the 6th, that is a pre-document that I sign off on before it goes to Cabinet, so it does change. What I will say, in the interim period from when I was appointed to when I learned there was a vacancy to when I learned that Seamus Woulfe had come through JAB, I did have a conversation informally with my colleague and with the Taoiseach. He informed me himself that there was a vacancy, that Seamus Woulfe had come through that process. I informed him that I was already aware of that. He also informed me, or I suppose gave a view, that he thought Seamus Woulfe would be a good judge. I did not make a decision then, because at that stage I did not have all of the other names. I only received them when I get the e-submission. That was on the 6th. This did not go to Cabinet till the 15th. There were 2 subsequent Cabinet meetings in between that time. So what I did was not bring it immediately, even though I had been told that this was urgent. I took the time to look at the Judicial Appointments Advisory recommendation, and it is a recommendation because it says that in the letter and also in the section of the legislation referring to JAB. I looked at all of the names that were and had come through the expressions of interest process, and then there was obviously a sitting list of judges, but they have not expressed an interest, so that is something that you look at last. Following that process, I spoke to all of the leaders as I've outlined in the time frame, and based on their response, I made a recommendation. So it's a very clear process.
So Minister, just to be clear, Minister, you're saying that basically you spoke to one person in Cabinet, and that was the Taoiseach in respect of this. And if that is the case, that means that yourself and the Taoiseach were the ones that made this decision. That's clearly what you're saying. And you're also saying, which is vital to this, that you did not inform the Taoiseach. The Taoiseach of the day in this country was not informed. And I want to know why you left the Taoiseach in the dark in regard to the decision that you and the Taoiseach made, this Fine Gael decision that was made, and the Taoiseach was left out of the loop.
So, Taoiseach, I'm not saying that he is, Deputy, I'm not saying that the Taoiseach is the only person I spoke to. I'm saying that he gave his view and made his opinion. Following that, after I received other names, I looked at those names.
So who else did you speak to?
Please let me answer. It is my role as Minister for Justice to make a recommendation. I made that recommendation to the Taoiseach, to the Taoiseach, to Minister Ryan and to the AG. Your colleague mentioned earlier a former Minister, Ahern. If you were to quote him from his article this week, what he actually said in his article is that not once did he ever bring more than one name or make more than one recommendation to the Taoiseach. In fact, he told them the night before. I am and have been, and any of the reference to, if you look at the handbook, what it says is, in the case of appointments to the judiciary, the Taoiseach, Taoiseach and other party leaders, the Minister for Finance and Attorney General should be informed in advance of proposals to make such appointments, and I did just that.
But you didn't inform the Taoiseach.
Sorry. Okay, we need to move on. The Labour Deputy Howland. Yep.
Go back and forth too, if I may. The Taoiseach's line of defence is that he couldn't have done anything improper since he didn't know what was going on. He didn't know who the contenders were and didn't seek to find out. So the Minister for Justice is left having to claim to be, as far as I can determine, the first Minister for Justice in history to personally determine a Supreme Court nomination without reference to the Taoiseach in a coalition government. Is that your position?
I would refer to my previous response, where other former Ministers for Justice have very clearly said that they never brought other names to the Taoiseach. No. What I am saying is that I made a recommendation. It is my job, it is my role as Minister for Justice to make a recommendation. When I made that recommendation to the Taoiseach did not object. What I would say is that it is a long-standing practice. It has been the case for many years that there is not just the Judicial Appointments Advisory Board process, there are expressions of interest
Don't
from
talk
judges.
out the time, Minister.
All right,
please.
Minister, can we hear Deputy
always
Howland?
been the process.
I've laid out the process and I'm familiar with it. I served in two governments with Fine Gael. The Minister for Justice brings a proposal after it has been debated at some length with the leaders of government. Why did that not happen in this instance? And can I ask you when we were first told of the application of Mr. Justice Woulfe for the position and who informed you?
Minister.
Deputy, again, I can repeat what is in the handbook. I cannot talk about what happened in a government that you served in. What I can say is, as Minister for Justice, it is my job to bring forward a name, and that is what I did exactly in this instance.
Did you refer to previous memoranda for government in checking the appropriate and normal form and contents of memoranda in relation to the appointment of judges?
Minister.
So in terms of appointing a judge, again, I will read out the only reference in the handbook to the appointment of judges.
That's not my question. I didn't ask about the handbook. I said, did you check other memoranda?
Answer the question. You're not answering any of them.
The only memorandum concerning judicial appointments that is referred to says that I should inform the relevant individuals that I've just outlined, the Taoiseach, the Taoiseach, the Attorney-General, any other party leader, and in this instance, the Minister for Finance, who was informed in the e-submission that would have gone to all of the Cabinet before the appointment was made.
It's very difficult when the questions are not answered.
Deputy Howland.
I didn't ask the Minister to quote the handbook. I said, did you look at the previous memorandum for government on judicial appointments to find the format, which doesn't normally just include, but there would be appendices normally listing all suitable applicants? Why was that not done?
So that is not the case, and as I outlined in my earlier response, what I receive initially is an e-document, which is a draft memorandum. I received that on the 6th. After I have signed off on that, it is then adjusted to be sent to Cabinet. It has always been the case that a name itself doesn't even go to Cabinet. A memorandum informing colleagues that a name is going to be brought for appointment, whether it's Supreme Court, District, High Court, anywhere else. That is exactly what happened in this instance. That is what happened previously. So there is never a case where multiple names are brought to Cabinet to discuss. It is always the case that one name is brought to Cabinet.
Thank
and
you,
Deputy,
Minister.
as somebody who has served at Cabinet, you would know that.
Deputy Howland.
Are you saying that it's never the case, and you've looked at the previous memoranda, and you're telling the House now that the previous memoranda circulated on the appointment of a Superior Court judge did not include appendices listing all those that were entitled to be considered? Is that what you're telling the House? And secondly...
That is my understanding, yes. That is my understanding, that is the precedent that has been set.
Did you look at the previous memoranda?
I have asked, and I have asked my officials, what is the precedent here? What I was informed is that no names went to Cabinet. So I asked the question, my officials in Department informed me that only one names go to Cabinet, and I think what we've heard from many other previous Minister for Justice, that only one name ever goes to Cabinet.
Were you
Deputy Howland,
aware of the existence of a previous non-statutory advisory committee set up by the previous Taoiseach, Leo Varadkar, to nominate suitable people for appointment, and why did you not have regard to that?
Minister.
I am aware of this non-statutory advisory group. I'm also aware that this group was established specifically for the sole purpose of appointments of Chief Justice and Presidents of courts, not for actual judges, but for the Presidents of those courts and for the Chief Justice. So this did not apply in this regard.
Thank you. Deputy Howland, you're finished.
It seems to me that the Minister's contention that she alone made that decision is unbelievable. Can you tell us, in making that decision, who else did you consult?
So in making that decision, I looked at all of the names myself. Before sending a name to Cabinet, I made my recommendation to the Taoiseach, Taoiseach, Minister Ryan and to the AG. Having had those conversations, I then made a recommendation to Cabinet.
Thank you, Minister. Sorry, the time is up. We have to go. Sorry, Deputy.
No,
I'm sorry. We have to go ahead to... who is Deputy Catherine Murphy?
Yeah, you've just told us, Minister, that you had a discussion with the Taoiseach.
Can we have order now, please?
Specifically in relation to the former AG. Did you have a discussion with the former AG, with the former Minister, with anyone else in relation to this appointment? And did you take it that the Taoiseach was saying that he favoured the appointment of Seamus Woulfe? Did he tell you that he had told Micheál Martin and Eamon Ryan that he had come through the job process?
Minister.
Firstly, Deputy, I did not discuss this with the now Chief Justice or the now Supreme Court Woulfe. I did not discuss this with my former colleague, Deputy Flanagan. I have said that I did have an informal conversation with my colleague and with the Taoiseach. He informed me that Seamus Woulfe had come through the process and that, in his view, he would make a good judge. He did not tell me that this was to be the case. He did not inform me of any other conversations that he had had with other party leaders, but I think the three of them have very clearly stated that this was said to them by the Taoiseach, and the Taoiseach and Eamon Ryan, Deputy Ryan, have corroborated that. Minister Ryan.
I've got to say, Minister, I just, like, the very fact that there was an informal discussion is an intrusion in the process, is pretty much saying, look, I'd really like to see this person appointed. This is who I favour. Before you go and have a look at the other list, can you tell us what criteria did you use following that to evaluate the other people against the person who was the preferred person by yourself and the Taoiseach?
So, Deputy, I think the Ken Corley has outlined that I cannot get into criteria. I'm not going to get into criteria. This is my job. What I will say is that there are still persons who applied for that position who are sitting on file in my department. There is still a vacancy there. So if that vacancy is to be filled, they will be again looked at. So it is not for me to get into criteria. What I would say is there is no specific criteria for me. I do not have a list. I do not have boxes that I tick. It's not given to me. I have to use my judgment, and I do apply my own set of criteria. I'm not going to get into that because we're talking about sitting judges, all of whom in this instance.
So judicial experience, track record, none of those matter. What matters? So there's no set down criteria for those. I mean, how could you possibly evaluate somebody for a job if you don't, if we can't understand the criteria?
We're going into difficult territory now because of what's known. We cannot start comparing one with
criteria rather than individuals. I'm talking about criteria.
What I have said is, for me to make that decision to engage with my colleagues, there is no criteria. However, if I could maybe outline through JAB, there's very clear criteria where they do make a recommendation. They have to show that the individual has displayed in his or her practice as a barrister or solicitor a degree of competence and a degree of probity appropriate to and consistent with the appointment concerned. It talks about suitable grounds of character, temperament, complies with requirements, is suitable. It also talks about the appropriate knowledge of the decisions and the appropriate knowledge and experience of the practice and the procedure of the Supreme Court or any relevant. So there's a very clear criteria coming through JAB. The recommendation that I made was somebody that had come through that process, chaired by the Chief Justice, the Presidents of the Courts, the Law Society, the Bar Council, and of course I took
Deputy
that
Murphy.
on board.
Like any job you go for, if you can, there's a scoring system. There's a mechanism to evaluate. It's very difficult to figure out how any Supreme Court judge or any judge will be appointed in a way that takes account of judicial experience and other relevant experience without some sort of a metric to do that. Other than you're doing it on an emotional basis as opposed to on a rational basis.
Minister.
Deputy, all I can say to that is the system is what the system is. I've said in my speech that it's not perfect, that we all agree that it needs to be reformed, but I can't change the fact that this is the current process. You have recommendations from JAB, you have expressions of interest from the sitting judiciary, and then you have a list of those who are eligible. It is then incumbent on the Minister for Justice to look at all of those names, to engage with colleagues, and obviously in this instance, where I made the recommendation, there were no concerns raised, there were no further questions asked, and the name was then subsequently sent to Cabinet. I cannot get into the criteria. As I've said, it is not deemed appropriate in this instance. There are members of the judiciary that are still sitting on a list in my office, and if this next vacant position I'm ever asked to fill it, then they will obviously be put forward for that also.
Questions come from Deputy Paul Murphy.
Yes or no, Minister? When you spoke to the Taoiseach about this matter, did you mention the fact that there were other expressions of interest other than Seamus Woulfe?
I have already said that I haven't. I made one recommendation to the Taoiseach, as is my job to do as Minister for Justice.
And when your party leader, Leo Varadkar, told you that he thought that Seamus Woulfe would make a good judge, did that weigh heavily on your mind when it came to recommending him?
That's, what I'll say is at that stage I had not received the other list. Of course I took that on board, but having then looked at the other names, I made a recommendation based on who I felt was the best person for the job.
And when Leo Varadkar expressed the opinion that Seamus Woulfe would make a good judge, was he in possession of the other names at that point in time?
I think the Taoiseach has already said himself that he was not, but I cannot answer for him other than what he has said.
And in making your mind up that going from the memo of, I think, the 6th of July to the point where you brought to Cabinet one name, you whittled down the names yourself. Did you speak to anybody else about that? About moving from 4 names to 1 name? Did you speak to anybody else in coming to that decision?
So firstly, Deputy, what I want to clarify, because a number of people have said it in this instance, I have never referred to how many names there were. There were 5 expressions of interest. It is not, I think, a good practice to start talking about how many names, but in the interest of clarity, I want to be very clear. There were 5 expressions of interest, plus the expression of interest through JAB or the recommendation. I have said very clearly that I spoke to the Taoiseach Taoiseach, Minister Ryan and the AG after I had deliberated. I did not move on this process immediately. It is a very sensitive process. It is a very confidential process. So no, I did not speak to officials or anybody else about that.
Thank you, Minister.
So you spoke not to a single person about this. You made the decision 100% by yourself that it would be Seamus Woulfe you'd be recommending as opposed to the other expressions of interest that you'd received.
I've already said that, but what I have also said, I think not just in this House but elsewhere, that I have never put forward a name to Cabinet without having full agreement of Taoiseach, Taoiseach, Minister Ryan and the AG, and this instance is no different. There were no questions, there were no concerns raised. In other instances where I have proposed names, there have been greater conversations, there have been back and forth. This did not apply in this instance. I made a recommendation, it was agreed by leaders, it was then put forward to Cabinet.
Murphy? In the same process whereby you talked to the Taoiseach, when you returned to talk to the Taoiseach, having previously had a conversation where he expressed the viewpoint that Seamus Woulfe would make a good judge, did you at that point in time inform the Taoiseach that there were other expressions of interest?
I think that has been made clear that I did not, and I think what's also clear is that it has been a long-standing practice that there are other names, that other judges put their names forward in expressions of interest. I think it's also clear from hearing from former Ministers for Justice that it is not always the practice that the Minister informs the Taoiseach or the Taoiseach of other names. They make a recommendation. That is what I did in this instance. There have been other instances because 6 appointments have been made in the last 4.5 months where questions have been asked, where other names have been discussed. That did not happen in this instance.
And when you brought the name to Cabinet of Seamus Woulfe, did you inform the Cabinet, not necessarily of the other names, but did you inform the Cabinet of the existence of other expressions of interest?
You can't get into Cabinet confidentiality, I'm afraid.
What I can say already is that the memo that goes to Cabinet does not have any names. It just says that a name is coming to Cabinet. But I think Deputy will be aware that I cannot talk about anything that's discussed with Cabinet colleagues inside Cabinet.
Deputy Murphy.
When you're in this process, all by yourself, not talking to a single other person, looking into your soul, presumably, and working out that it's Seamus Woulfe's name that's going to emerge, on what basis do you make that decision? On what criteria do you make that decision? Not at all asking for the qualities of Seamus Woulfe relative to the other expressions of interest, but what kind of things did you take into account in saying, yes, he'd be the right person here?
Minister.
Again, Deputy, all I can say is that, and the Ceann Comhairle has been very clear, that it is not appropriate for me to discuss criteria here. I've already explained there is no list or boxes that I'm given to tick. What I would say, and you're suggesting that obviously this was a huge decision to make, upon being appointed Minister for Justice, you immediately have a number of huge decisions to make. I take my role and my job as Minister for Justice very seriously, and I very seriously considered every single name that was put before me before making a recommendation, which was then agreed by those members, Taoiseach, Taoiseach, Minister Ryan and the AG, and then subsequently agreed by Cabinet. It is the prerogative of Cabinet to reject a name, to not approve the name. That again did not happen in this instance.
Thank you, Minister. We go now to Deputy Peadar Tobin.
We're not being given any qualitative criteria because there is no qualitative criteria. It's as simple as that. It's not difficult to understand at all. Minister, how many candidates did you consider for the role?
So again, I have just outlined that there were 5 expressions of interest. There was one name that came through the Judicial Appointments Advisory Board, and then there is a lengthy list of suitable judges, but they are not people who have expressed an interest in this role.
Okay,
so they are the last that
there's 3 lists, and I do want to ask how many candidates did you consider for the role? And the reason being is because we want to bring transparency, and if we don't know how many candidates were considered for the role, it's not transparent. Now, you've mentioned the people who have an expression of interest. Outside of that, there's another list with judges who are available and have the experience to do it. So how many candidates were considered for the role?
Again, Deputy, what I will say is I looked at all of the names that were put before me. 1 from the Judicial Appointments Advisory Board, 5 expressions of interest. Again, I'm saying that in the interest of clarity. It is not practice that you give away the number of names or you say the number of names of expressions of interest. And then there is a long list that changes, but I don't have the exact number of that. There is a long list of eligible sitting judges from all of the courts who have not expressed an interest, but there is a statutory obligation, there is a legal obligation to look at the Judicial Appointments Advisory Board list first, then the expressions of interest, then the other general list.
It's not practice to have clarity on this whole process, and that's one of the reasons why we're here, is to actually change that practice. Okay, Minister, you said on a local radio, both of ours recently, that you were only asked to fill one Supreme Court position. Who was the person who asked you that?
When I came into the department on the 28th, I received my briefings, an updated memo, or I received my briefings which said that there was a vacancy and that the Chief Justice had asked for that to be filled immediately. What I made reference to in my speech earlier is that because lists had been reduced in the Supreme Court, there was a tradition that not all of these had been filled when it needed to be filled. Okay. This was before I came into the department. The Chief Justice wrote to the then Minister Flanagan to say that he wanted this to be filled.
Right.
I think it's been made clear that it wasn't filled because we were in an interim government, COVID, everything else. This was then set to immediately when I was appointed.
So the Chief Justice, you're saying, asked you to only fill one particular role on the court. Is that correct? And given that there are thousands of cases, lengthening by the year within the system, given that the court system in this country is underpowered with regards to judges, it's very hard to believe that with multiple applicants, access to different lists, that why you would not fill more than one particular position on the Supreme Court. Now, the view of the people around the country is we have a rotating Taoiseach, so therefore we have a rotating nomination for the Supreme Court. And that's the view of the people. And there hasn't been given... Can you give a good reason why the people are wrong on that, Minister?
Deputy, I have been asked to fill one position. I have filled that position. There is currently a vacancy, and if the Chief Justice asks me to fill that vacancy, I certainly will. Any other vacancies that have arisen since then in the District, in the High Court, in the Court of Appeal and the Circuit Court, when I have been asked by the presidents of those courts, I have filled them. If I am asked to fill this vacancy, I will. What I do not believe is that we should choose judges based on their ideology or decisions that they have taken, and I certainly do not think we have a situation, unlike we have seen perhaps in the US, where elections are hinged on who gets to pick the next Supreme Court. I don't think that is the route in which we should go, nor do we.
Your response contradicts the behaviour of the Chief Justice and other Supreme Court judges before, who have actually gone to the government demanding that the government actually fill positions within the judiciary. And to be honest, when I think it's not feasible for a minister to say, I wasn't asked to fill a role. The minister is driving the department. The minister's decision and responsibility is to fill that role, nobody else's. So the minister needs to have a criteria to leave a gaping vacancy within that. And the only vacancy, or the only criteria for that vacancy currently is a rotating Taoiseach, so therefore a rotating nomination there as well. Most of your focus, Minister, has been on the particular list from JAB, and we have had very little focus on the other two lists, the expressions of interest lists and then the lists of available judges. Is it not a two-tier process then? If JAB is the primary focus of selection of a judge, do the other judges then not have a real grievance that their expressions of interest, or at least their ability to do the job, have been ignored by the Minister?
Very briefly, Minister.
Deputy, it is a legal requirement that in filling a position of a judge, you do look at the Judicial Appointment Advisory List first. It is actually the opposite when you are looking to fill the President of a court or the Chief Justice. You have a legal obligation to look at the sitting judge list or the expressions of interest list first. So that is what is in the legislation, and that is what I have adhered to in this instance.
Thank you very much. Deputy Matthew McGrath.
Well, Concorder, I was a Kate Kesht. Why was there a 7-month gap to fill retired Justice Mary Finlay-Gagan's position, followed by a frenzy of activity at the general election time when Seamus Woulfe had applied for the position in January?
Minister.
Again, Deputy, I can set out 16th of June last year, vacancy arose. 4th of February, Chief Justice wrote to the Minister. 17th of February, letter to JAB to try and fill that. 18th of February, Minister responds to Chief Justice, letter of the 4th of February indicating the issue to JAB to request a list. 25th of February, Chief Justice replies to letter of 18th indicating JAB meeting scheduled for 9th. JAB met on the 9th. 11th, the list was received. In between that time then, there was a general election, there was an interim government, there was a very clear decision taken not to appoint anyone, bar the President, to the High Court for the reasons I've outlined. It was made aware to me that this was urgent. At the same time, I did take the time to look at all of the names. I did not appoint somebody immediately. There were 2 or 3 Cabinet meetings that happened before I eventually brought a name to Cabinet.
Thank you. Deputy McGrath.
Why was there a 14-week gap between when Minister Flanagan, or Deputy Flanagan at that time, receipt of Seamus Woulfe's name from the JAB and it coming to the new Cabinet? And, you know, in that same time, Miss Mary Irvine was appointed to the presidency of the High Court during the caretaker government interim period. But Mr Woolf's appointment was kept back for the new government. Ken Faw.
Minister.
Again, Deputy, I have outlined that a decision was taken by the interim government not to appoint anybody except to the presidency of the High Court because of the obligations upon the presidency and I suppose the requirements for that. The decision was taken not to appoint anybody else. However, I was made aware on my first day that there was a vacancy, that this was something that was urgent. Even with that, though, I made sure that I took the time to give everybody due consideration before I made a recommendation. But this recommendation was made within about 2 or 3 weeks, I think, from government being formed.
Deputy McGrath.
I wonder would it be anything to do with the fact that Minister Ross and the former Ministers McGrath were in the Cabinet at the time as well. We'll have, let the people judge that. I'm asking you, Minister, now, as new Minister, the Judicial Complaints Board, and I believe the offices are rented and it's staffed and it's everything but a doorman. I said, when will that be in action? When Joe Soap or Joe Public can make a complaint to that board that was passed by this House and signed by the President into law 7 or 8 months ago? When can the public get access to that, or what's the delay, or who's been protected by not having this complaints board in place?
Minister.
In terms of judicial conduct in that process, everything that has been done or needed to be done by myself, the Department and the Government has been done. The terms of reference are now being set out by the Judicial Council. They have a certain period of time to do that. I am assured that they are working on that and will have that done as soon as possible. But I can assure the Deputy everything that needed to be done from our part has been done. The terms of reference are now being set out by the Judicial Council.
Deputy McGrath.
This is like a former presenter of Kelly House. I think he was O'Hanlon, I can't think of the name. Around the house, Councillor, mind the dresser. We have to mind things here. I know we have canned stray, but this was passed, and why isn't it in action? Why can't the public today, many of them who feel aggrieved? Deputy Connolly mentioned about they not being able to access it, but some that have accessed those places, especially lay litigants, have complaints to make, and there's no complaints process. Even though this House has implemented it, passed it, who's blocking it?
Minister.
I can confirm nobody is blocking it. There is a process, there is a time frame. It is with the Judicial Council. They are setting out the terms of reference, and I'm assured that they will come back as soon as possible. But from this House's point of view, everything that has been done or could be done at this stage has been.
That's strange, because we passed laws here about vulture funds, and we passed laws here to remove the hearsay evidence and to implement the hearsay evidence, and it's implemented immediately. Why do we have to wait for a year nearly to have this body that's set up and staffed and rented buildings and everything else? and a great cost to the taxpayer, to deny the taxpayers the luxury, not luxury, but the solace of making a complaint. Not saying how far it'll go or what it'll get, but it's farcical that we spend time, a lot of time here. And I want to thank Minister Ross as well for all his work on that. And then it's set up and signed by the President in law. People would expect that it would be up and running. Why is it not up and running?
Minister, to conclude.
I can only refer to my previous comment. It is often the case where legislation is signed into law here and there is a period of time where that then has to be enacted. In this instance, it is with the Judicial Council. They're setting out the terms of reference, and I have no doubt that when that is done, this process and this procedure can get up and running.
Thank you. Thank you, Deputy McGrath. Deputy Michael McNamara now.
Thank you very much, Count Corla. Minister, like Deputy Tobin, I too listened with interest to your interview with LMFM, and in particular the part where you said you knew there were 2 vacancies in the Supreme Court, but you were only asked to fill one. So you filled one, and when you're asked to fill the other, you'll fill it. However, the Courts and Court Officers Act 1995 states, section 16.5, where more than one judicial office in the same court stands vacant, or in advance of more than one vacancy arising in the same court, at the request of the Minister, now not the Chief Justice, the Minister, the Board shall submit to the Minister the name of each person who has informed the Board of their wish to be considered for appointment, etc., etc. So, did you or your predecessor agree with the Judicial Appointments Board that you were only going to fill one of the vacancies?
Minister.
As you were saying, I do ask, or the Minister of the day asks, the Judicial Appointments Advisory Board to set the wheels in motion to make recommendations. However, I only do so when I am asked either by the President of the relevant court or the Chief Justice to fill that vacancy. In this instance, there were 2. The second only arose a very short time before I came into this role on the 27th of June. I was asked to fill one role. In the time since then, I have not been asked to fill the second role. However, if the Chief Justice asks me to do that, I will of course do that, and I will set the wheels in motion.
So it's clear that you asked the Judicial Appointments Board to fill one role. Thank you. The next question, the law is very clear about who needs to sit on the Judicial Appointments Board. Indeed, you listed them on LMFM. Can you confirm that all of those people who are required to be on the board sat on the board and that it was duly convened? Because it's important, because the Judicial Appointments Board is really what all of this is about. You're kind of sheltering behind it, if I may say so myself.
Minister.
So, Deputy, I can only assume that when the board met, yes, all members of the board were there, and I've outlined those who sit on it. I cannot tell you otherwise, but I'm assuming that every time they meet, the full complement of members meet. That is their obligation.
But it has never been confirmed to you one way or the other.
No,
thank you. The rest of my time goes to my colleague.
Deputy Catherine Conlon.
Thank you, Minister. Thank you, Minister. Just the 5 who expressed an interest, presumably they were sitting judges. To whom did they express an interest?
So it was formerly, I think, before 2014 or 15, the process where the names came directly to the Minister. That has since changed, where they go directly to the Attorney General's office but come directly to my office. It is my understanding, and I can't confirm or deny, but it is my understanding that they do not stay in the Attorney General's office, that they come directly to my office, to my private office.
Sorry, I just didn't hear that. The 5 persons that you refer to, where did their expressions of interest go precisely?
The Attorney General's office.
They went to the Attorney General's office. Yeah. So they went to the Attorney General's office. So the Attorney General knew which sitting judges had an interest in going to the Supreme Court.
Again, my understanding is that it comes directly from the office into mine. Whether or not they see them, I don't know. What I will say, in these 5 expressions of interest, there were expressions of interest from as far back as 2017 to as recently as June of this year, which obviously the former Attorney General would not have been privy to. But again, it is my understanding it goes directly to their office, or from their office to mine. It is not. I'm not sure. It is not held there, so I cannot respond.
I've no wish to make your life difficult, but you can imagine how this sounds to people listening and watching. So 5 sitting judges express an interest in going to the Supreme Court, and they send in their expressions of interest to an office, the Attorney General's office, and he himself has an interest in being promoted, and nobody reflects on that as a procedure and a practice. And you stand here today and talk about traditions and practice. Just let me finish, because by my time. Sorry. And the second thing is, again, I'm a little confused, because I heard you say that the current Taoiseach and the former Taoiseach said that the Attorney General would make a good judge. But yet he said that, but you didn't discuss it with him, number one. And then number two, if he had an opinion on that, did he have an opinion on the other sitting judges who wished to go higher?
So firstly, on the process is what it is. As I've said, it changed, so the names do go to the Attorney General's office. What I would say in the legislation itself, the Board may recommend the Attorney General for appointment to judicial office, so that is very clearly allowed and stated. The fact that these names come through the office, as I've said, there is a requirement, I think, and we all believe that there should be an updating of the current process and the legislation, and that's something that I'm working to do. In terms of the Taoiseach's comments, what he said was that he thought Seamus Woulfe would make a good judge. There were no further discussions about other names because at that stage I had not received the other names. This was before the 6th of July, at which point then I received the names. And the reason I did not have those names is I am only given the names of the expressions of interest after I indicate that something is going to Cabinet. So I always have the Judicial Appointments Advisory Board nominations before I see the other ones.
Thank you very much. Yes?
Debate ceases. Corla, the revelation that the Taoiseach indicated to his newly appointed Justice Minister that a particular individual would make a good judge. If you allow me to get to it, if you allow me to get to it,
well, no, it's not a point of order.
And the Justice Minister's clarification that informed her position and her view in terms of her consideration of the appointment, to me, sets out a very clear terms that we need an urgent statement of clarification.
No, Deputy, that is a political charge. It is not a point of order. Thank you. Well, no, I can't take it. I can't take it. Sorry, Deputy. Deputy, please, look. Deputy, resume your seat, Deputy. Please resume. Will you resume your seat, Deputy, please? Have a little respect. Have a little respect, please. Well, resume your seat. Resume your seat. Resume your seat. Resume your seat. You can't get up and purport to be moving a point of order and then proceed to make a political charge. There's no provision for that here in the process that we're involved in. I'm sure in Europe there were procedures that you learned to follow. We'll have to follow the same sort of procedures here. Now, I'm going to ask the Minister. Excuse me, Deputy, resume your seat. 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 If you want to find some other avenue to pursue that matter, find it. But it doesn't exist here and now. We're going to hear the Minister now make a 5-minute wrap-up of her contribution. Minister.
Thank you, Corlia. Maybe just to respond to the last comment.
It might be better that you didn't.
Well, what I hope I have done this afternoon is very clearly set out that there is a process when appointing a judge, not just a Supreme Court judge, but a judge to any court. I have, as Minister for Justice, adhered to that process, and just to outline it again for absolute clarity, I was appointed as Minister for Justice on the 27th of June. The following day, I received briefings from my department, one of which outlined that there was a vacancy in the Supreme Court. I was asked to fill that as soon as possible. I was also made aware that there was already a Judicial Appointments Advisory Board nomination or recommendation in my private office, which alerted me to the fact that the former AG had come through that process. I later that week, in discussion with my colleague, the Taoiseach, was informed that this process existed, or that the former AG had come through, so I informed him that I was aware of that, and he simply said that he believed he would make a good judge. Of course, I took that on board, but at this stage I had not received all of the other expressions of interest. I received those in a draft memorandum on the 6th of July. Following receipt of that, I looked at all expressions of interest, the recommendation through JAB, the sitting judges that are eligible for this position, and following a number of days, if not beyond 2 other cabinets, I then spoke to the Taoiseach, Taoiseach, Minister Ryan, the Attorney General. I made a recommendation to all 4 of them. There were no further questions. All agreed with the recommendation that I had put forward, and it was on that basis that a name was presented to Cabinet, and that Cabinet, or that particular Cabinet, approved Seamus Woulfe as Supreme Court Justice.
you very much, Minister, and that concludes today's consideration of these matters. We now